The subject is ownership. My name is Umesh Rao. This subject is covered under jurisprudence. In this class, we are discussing what is the meaning and definition of ownership, essential features of ownership, mode of acquisition of ownership, and different kinds of ownership. The meaning of ownership. Ownership is a bundle of rights. Ownership has four kinds of rights. Owner, he has the right to use a thing. Owner has a right to exclude others from using them. Owner can dispose the thing. Owner has a right to destroy the thing. Origin of ownership. When they started original ownership? During the Stone Age, there was no possession, no ownership. Jungle Raj was prevailing. There was no family system. Occupation of the people only hunting, fishing. These are the living sources. Agriculture was not discovered. Man, what he hunted, what he possessed, and what he ate it. During the Metal Age, status changed. The idea of possession gradually changed into the idea of ownership. Agriculture was invented. Man started to store things for tomorrow. Man started to claim the ownership. As per history, idea of possession came first in the mind of the man. Next, ownership came into existence. The definition of ownership. Owner can use his property in a manner what he likes. Owner can transfer his property. Owner has abundant authority to have the property till it's destroyed. Ownership is inheritable. Now, essential features of ownership. First feature is the possession. To become an owner, he should possess the thing. Owner has a right to possess the property which he owns. But sometimes possession is not always necessary. For example, A has a car. His car was stolen by X. Now car is in the possession of X. But A is the real owner of the car. A is the immediate owner of the car. Another example, A lends watch to C for hire. A has no possession of watch. A has no immediate possession. A has no right to possess. Still, he is the owner of the car. Still, he is the owner of the watch. Second one, owner has a right to use and enjoy the thing. He has a right to manage the thing. He will decide how to use and how to get income from it. Owner can consume, destroy, alienate the thing. He purchases commodities from the shopkeeper. He becomes owner. He has the right to consume. If he found the things are not good, it is spoiled, he can destroy it. He has the right to destroy it. He has the right to alienate it. He can alienate by way of sale, exchange, mortgage, or gift. Owner has the perpetual ownership of his property. Ownership is not determined by a fixed period. He can transfer the enjoyment to others temporarily by way of lease and license also. In such a case, ownership remains with the owner. Only enjoyment for the temporary purpose is transferred to the licensee or lessee. Owner, right of ownership is heritable. from father to son. Ownership will go to his next kin. Ownership has a residuary character. Owner can lease, license, mortgage, and easement rights. All these are available for the ownership. He transfers the property in this case. In these cases, owner has the residuary power on the property transferred. Now, mode of acquisition of ownership. There are two types of ownership, mode of how to original ownership and derived ownership. Original ownership. What is the original ownership? For example, fish caught by fisherman, animal caught by the hunter, paint painted by painter, book written by written. This is called as original ownership. Owner he himself owned it. Another is the derivative ownership. Ownership is acquired by purchasing the property from the original ownership. For example, ownership is acquired by purchasing the property from the original. Person buys fish from fisherman. Person buys painting from the painter. This is called derivative ownership. The difference between ownership and possession. Ownership is de jure, possession is de facto. The idea of ownership followed the idea of possession. The idea of possession came into existence first, then followed idea of ownership. So ownership is de jure, means it is recognized by the law. It is recognized the right over the property. Possession is de facto. It is not recognized by law because he is in possession of the goods. That is the only thing. Ownership has having a wide meaning. The concept of ownership is used in the widest meaning. The owner has the right to consume. Owner can destroy the goods. Owner can alienate goods with free will. The concept of possession is narrower meaning. The possessor has limited rights and to destroy, consume and alienate the property. Residuary power vested with the owner. Here residuary power is not given to possessor. Ownership is guarantee of law. It is recognized by law. Possession is guarantee of fact because till as of now he is in the possession of the goods. That only fact. Ownership is right in rem and possession is right in person. See, ownership means right in rem. The whole world has to recognize the ownership. Possession means it is only particular individual is concerned. Ownership contains multiple rights and possession contains singular rights. Now, kinds of ownership. Ownership is exclusive, immediate, unconditional, and beneficial. Kinds of ownership: corporeal ownership and incorporeal ownership. What is corporeal ownership? Corporeal ownership is the ownership of the material objects. It is seen, it can be seen, it is tangible. It means possession of a material object is corporeal ownership. For example, house, car, cycle, book, pen, computer. Ownership of the right is also corporeal ownership. Incorporeal ownership is the right of right. It is the ownership of rights. For example, copyright, patent, trademarks. It is the ownership of anything other than the material objects. Now, sole ownership and co-ownership. What is sole ownership? Ownership is vested with the single person. All individual ownership are the example of single ownership. By combining two or more sole ownership, co-ownership is formed. So co-ownership means property is owned by two or more persons. Co-ownership is called duplicate ownership. For example, members of partnership firms are the example for co-ownership. Trust ownership and beneficial ownership. We have to know what is trust. Trust property is owned by the two persons at the same time. Trust ownership and beneficial ownership. What is trust? I have a certain property in my name. I make a declaration of trust in favor of poor students. I appoint Mr. A as trustee to look after the property and maintain the trust property. So I am owner till the trust is formed. As soon as the trust is formed, my ownership disappear. Mr. A, the trustee, is placed in position of direct ownership. Poor students are the real owners. Poor students are the beneficial real owner, and Mr. A is the trust owner. So in this case, trustee is only a nominal owner. Trustee is the agent of poor student. As per law, he is also deemed to be owner. Trustee to use his ownership for the benefit of the poor or other person is called beneficial ownership. So beneficiary is the real owner. Trustee has a only minimum ownership, bare ownership. Trust created for unborn persons, disabled persons, or some common interest of persons. Now, legal ownership and equitable ownership. Legal ownership is one which has its origin in the rules of common law. What is legal ownership and equitable ownership? A is the owner of the shares in a company. A transfers shares to Mr. B. B pays the amount to A as consideration. But as per rules of the company, proper transfer deed was not executed, because proper transfer deed has to be executed, but it was not executed. As a result, company refused to register Mr. B as the shareholder. Law says A is the owner of the shares, but equity says A holds the shares as trustee for Mr. B, because A received the money for shares. All dividend will go to B. Here A is the legal owner and B becomes the equitable owner. Legal ownership is certain and equitable ownership is uncertain. The concept of equitable ownership has arisen from the rules of equity. Now, vested ownership and contingent ownership. Vested ownership is perfect ownership, it is absolute ownership. Vested interest is heritable. Vested interest is not defeated by the death of the transferee before he obtains possession. Transferee acquires all rights of a full owner. Contingent ownership is imperfect. It becomes perfect only on the fulfillment of condition. It is conditional. Contingent interest is defeated by the death of the transferee before he obtains possession, because interest in the contingent transfer is not complete. Ownership is merely conditional. Ownership, in the case of vested ownership, it is no need of fulfillment of any condition. It doesn't depend upon any condition. In the case of contingent ownership, it is only depends upon the fulfillment of the condition. If condition is not fulfilled, property will not be given. For example, X promised A and B to give 1 lakh each if marriage occurs before his death. B married before the death of X. Gift becomes valid or vested to be on such a marriage. X promised A and B to give 1 lakh each. B married. A did not marry before X's death. Condition he did not complete it. Hence, A cannot take 1 lakh. Now, absolute ownership and limited ownership. All the rights of ownership like possession, enjoyment, disposal are vested in a person without any restrictions. The ownership is absolute. When there are restrictions as to its use, duration, or disposal, the ownership will be called a limited ownership. Thank you.